She could have very easily died. I believe it warrants every bit of the 10 years.
I have no intent to try to kill her.
Are you kidding me? You're going to stand by what you just told me? This was no big deal. You stated, I'm going to do good. I'm not really a drug guy. Really? What are you? Was this caused by drugs?
No, sir.
So this is the way you act when you're sober?
That's a good question, and as usual, it is Judge Stevens who's asking it. He doesn't miss much. He didn't miss the word salad the defense attorney used to describe how his client didn't actually break into the house, and definitely didn't miss the defendant minimizing a brutal assault. Keep watching for the courtroom outburst right after Judge Stevens hands down hard time. Following that, there's a bonus hearing where a guy is in for a brutal assault on a new girlfriend just 3 months after being put on probation for doing the same thing to his last one. Let's roll, nerds.
Come forward, please, sir. And we now call 25 CR 329, the state of Texas versus Charles Darrell Johnson Jr. That's you.
Yes, sir.
Present with Mr. West, your attorney and the state's attorney. Okay, everybody?
Yeah.
All right. Earlier, you pleaded guilty to this indictment, which alleges the second-degree felony of burglary of a habitation. A pre-sentence report has been prepared. Have the parties had an opportunity to review the report? Are there any corrections or changes to it, State?
None from the state, Your Honor.
None from the defense.
Then it is made a part of the record for all purposes. There is an agreement that's been reached where whatever sentence the court assesses shall not be more than 10 years imprisonment. So he could be placed on deferred or unadjudicated probation for up to 10 years from that. And he could also be placed on regular probation. I could sentence you to no less than 2 nor more than 10 years in prison and then suspend that and place you on regular probation. But you've been on probation before. Go ahead.
We're going to ask the court to put him on probation, and we're going to let the court decide whether regular or straight is a term of probation. Looking back at his criminal history, as you see,
His time, the credit, please. Thank you. Go ahead.
and like the court just mentioned, all of his prior criminal history is all from drug issues. The most recent one looked like the last one was in 2012 was the last conviction. So it's been quite a while since he had any problems with convictions. The biggest thing I want to point out on the PSI, Your Honor, is in the statement of interested parties that the victim of the case, who I don't know if the court remembers, we actually had a trial. This was a plea during the trial. Ms. Part already testified about what was going on. But she did state there in her statement that she does not have an objection to the defendant receiving probation.
Everybody has reviewed the pre-sentence report.
Yes, sir.
There aren't any objections here. No. Okay.
Yeah, I know that.
All right. All right. Go ahead, State.
Your Honor, the facts of this case are particularly egregious. He sneaks over to her house, snuck up there on his former girlfriend. He had taken her kids out of the house prior to that in the morning. And he just starts beating her, ends up choking her out several times where she passes out. And she's eventually able to escape. He flees, and then the kids suddenly show up again after he drops them off down the road. Again, she could have very easily died in this situation, Your Honor. I believe it warrants every bit of the 10 years. And even now, the defendant continues in his PSI to contradict the evidence that was presented in the testimony for both her and what her kids, the statements her kids had given as well. He continues to not take responsibility. And in fact, he says, I went ahead and went with it because he said I could get 20 years and I didn't want 20 years. So I still don't have him acknowledging that he did this. And he's still not taking responsibility, Your Honor. And I believe he deserves no less than the 10 years, Your Honor.
Any response?
Your Honor, we can let Mr. Johnson testify about that if you don't mind. I can call him as witness about that.
Okay. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go ahead, Mr. West.
Mr. Johnson, part of the indication says here that you didn't break into her house, and you still believe that you did not break into the house, correct?
Right.
Okay. You didn't go in the house uninvited, correct?
We went into the house.
Hold on. Hold on. Hold on. Hold on. It's all about what the facts are.
Yes, sir.
I asked everybody, is there any changes or corrections to the pre-sentence report? And there were none. Let me read the second line of paragraph 2 under police version. The second paragraph, on the above date, Charles Johnson snuck up on his girlfriend, Nisha Parr, as she was trying to enter her residence in Beaumont. Johnson then forced his way into the house behind her and began assaulting her. I'm sorry. He forced his way is a violent act. Okay, let's correct the record. You weren't invited in. It says you forced your way in, which means it was without her volition, and then assaulted her.
Your Honor, this is not his statement. He doesn't. What I'm getting at, I was getting to question him, is that he was there. They went in. It wasn't a situation.
He's saying the police are wrong in this report.
Well, the
Is that what he
police.
said? Well, let's come on.
Well,
Let's get it
let's-
straight. Is this nobody objected to this? That's what makes me
Because that's-
unsettled. I've got to make my decision on the facts. No one objected to this. This is here. He forced his way in.
Your Honor.
Is this wrong or not?
That's the police version. I can't say their version is what they put down as wrong.
Do you debate their version?
We do. His
all right,
is
but
different.
That's what, well,
It's not, we can't
but
object to
you-
what the police
you need
say.
to- If there's a big difference between what is being said here by the authority that wrote this and you, point it out to me.
Okay.
I mean, I do read this, but
Yeah.
sometimes
Also, Your Honor,
these things pass by unless they are emphasized, because this is a big problem right now. He says one thing, the police are saying another. I'm going to be the fact finder. Go forward.
Well, Your Honor,
Go forward.
we had the trial, and the defendant or the victim even testified to that. Okay, but his position is that, and I'm trying to give a question, is that he did go in uninvited, kind of forced his way through, but it wasn't a situation where he broke a window or broke a door or went in that type of.
He was convicted of intentionally and knowingly entering a habitation without the effective consent of the owner with intent to commit assault.
Okay.
What we're trying to get to are the facts. What's the truth?
Right.
And somebody's version may be different from the facts. Go ahead.
Right. Well, I think the facts are, like I said, the facts are the
I'm
facts.
a fact finder.
He went in without permission, and some bad things happened. I think there's no question about that. Okay. The question is in his report. I'm trying to correct his version here, or let him explain to it that it wasn't that he broke into, because I think they asked him when asking the defendant if he broke into the victim's house. The defendant said no. Okay. So I think that's the issue here. Is I don't believe he broke into, meaning broke in a door, broke in a window, something like that. But he did enter. If they would ask, did you enter without permission? That'd have been a different question. Okay. So I just want to make sure the court that that's correct. But I think the court needs an explanation of that that's the difference there.
And it goes, upon entering the residence, this state, he began assaulting her and dragging her through the house by her hair, using his hands to strike her and threw her body about the room. Then used his hand at the front of her throat, grabbed her trachea, then squeezed her throat, cutting off her breathing and causing her to pass out. So does that look like he was invited and welcomed in there, or he snuck in behind her and immediately began to assault her? That's not forcibly entering.
When Your Honor, there was testimony from the victim that he was in no way invited. And in fact, he showed up behind her as she was going in through her garage and ran up on her
You agree
and
with that?
went into the house.
Yes.
Okay.
But I'm just saying that the phrase broke into, I think that I don't want
We're semantics now. Well, I'm talking about he committed the crime of burglary and she was assaulted.
That's why I was-
Let's move on to what the points are.
Well, okay.
We're bogged down on how he entered the
Right.
building, but it was for no good purpose.
It was not with permission. It was not for a good purpose, right? But it wasn't a situation where he broke into. I think so. I don't want the court to say that he lied here, because I think his version is that he didn't break into because he doesn't understand what the law says. Okay,
Wait, did he enter her home without her permission?
absolutely.
Okay, so he trespassed. Okay, Okay, that's a crime.
I know. We're not saying that he
To
didn't.
get in, he committed a crime.
We didn't say that he didn't commit a crime.
Let's move forward.
Okay, all right. But like I said, I like to go back to the point where even the victim in this case indicated that probation would be good for him, or she would have no objection to it. And I still think that probation with a restriction to keep him away from her and all the conditions of probation to making sure he lives right would be good. I know he has violated probation in the past. However, in the past, it was a drug-related issue, and it's been quite a while since his last probation. So I think this is the type of case that this would keep him under the court's authority, keep him under the court's eye through the probation department. That this would be helpful for this both the victim and the defendant in this case.
So,
The victim here could have died multiple times. He passed out several times. And by the grace of God, she didn't end up dying and was able to escape. And who knows if she wasn't able to escape, and one of the times when she asked to go to the kitchen, what would have happened in the end. So sometimes we have to protect the victims also. In these type of relationships, we know they tend to want to be lenient on the defendants. However, that's a dangerous situation, and what he did was extremely dangerous and horrible. And with those kids, again, dropping them back off over there, and they have to see the house being completely busted up, knowing their mother has been strangled and beat. I believe, again, every bit of that 10 years is warranted in this case.
What would you like to say, sir? This is your time.
before we told me to everything that happened,
What happened?
me going,
Because he's saying something different than he is.
I went into a house without permission.
And then what?
Yeah, really. No price.
Then
No
what?
price.
Or she punched you first?
No, sorry. I grabbed her phone and she grabbed me and we started wrestling over the phone basically. I had no intent to try to kill her or harm her or do anything.
Well, it says you dragged her through the house, used your hand to squeeze her throat, cut off her breathing, causing her to pass out. When she would regain consciousness, you would continue your assault and squeeze her again. This assault went on for several hours before she was able to escape her house, running to a nearby business where a citizen was able to contact the police for her. She sustained injuries in the form of abrasions, scrapes, cuts, and bruises all over her body. Are you kidding me? You're going to stand by what you just told me, that really nothing, you didn't intend to do anything, this was no big deal, in spite of what this says? You don't understand and appreciate the seriousness of what happened in this person's home where she's supposed to live in peace?
Yes, sir.
Okay. Here's another statement that I don't understand that you made to the probation office. When asked how you're going to do if granted probation, you stated, "I'm going to do good. I'm not really a drug guy." Really? What are you? How many convictions do you have of drugs?
It's pretty.
Wrong. Do I know more about you than you do? No, in 98, you were convicted. 1 year adjudicated probation of illegal possession of marijuana. In 2003, 30 days in jail. In 2012, 30 days in jail, marijuana. In 30 days in jail. In 2002, let's talk about the felonies now. 2 years state jail, probated for 5 years for drugs. That's 5. That was revoked, and you received 6 months state jail. And then in 2009, 6 months in the state jail. 2000 and 1, 2, 3, 4 misdemeanor drug convictions. But you're not a drug guy. You don't have an answer to that.
No, that's me.
Because it's just nonsensical.
Speaking about recently,
Well, recently, you mean since you've been in jail? You don't use marijuana in
The
jail.
last 12 years, I haven't been.
Let me ask you this. This event, was this caused by drugs?
No, sir.
So this is the way you act when you're sober?
No, sir.
Yes, it is. Okay. Within this. Dead. If not, I'm going to find the defendant has pleaded guilty voluntarily. He is mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilt, your plea of guilty from State's Exhibit 1 admitted to your hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt, and I am following this agreement. The agreement is whatever sentence shall not exceed a cap of 10 years imprisonment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You can leave.
Ma'am.
You can leave.
You step outside, ma'am.
Step outside. This is what we call justice. Your rich criminal history. You have a rich criminal history. You're held in contempt of court. Get her. She'll be. You can't make an outburst in court.
Get it.
You're going to be given credit for all time you have served, but you can't invade somebody's home and assault them. And with your rich criminal history, we know that.
Yes, sir.
All right. Okay. Anything else to add?
No, Your Honor.
That is all. You can't make an outburst in this court. You can be held in contempt of court up to 6 months, ma'am. Are you related to somebody here?
I'm sorry, sir.
Or that's okay. Or are you related to somebody? Who do you know? This man?
Yes.
How do you know him? He's your brother. All right. You were here and you heard what this was all about, right? Did you hear? Okay. It's a very serious thing. And his criminal history was, but here's an issue when he gets out, the family needs to help with this. It's still a drug issue that he's struggling with. And he says he doesn't have a drug problem, but I think a lot of this is based upon what is out there. People don't know what's out there. What the people are manufacturing cause folks who take it to do odd things. And it's very serious. Some people are dying out there right now for some of this. But I think you're a rational thinker when you're not inebriated with drugs. And I just wish that seems to be your problem. But then you tell me I don't have a drug problem, but you've got all these convictions for drugs. But it's one of these things that the family's going to have to help you. John, I want you to talk to me about what you might be able to figure out what plan you might be able to do to put him into a facility, which this court might consider doing before this term is completed. You know what I mean?
Yeah.
Because he needs help.
Okay.
And the family seems to be supportive of him, but you've got to be firm that his actions can't be tolerated. And it's Christmas time. It's supposed to be where the family gets together and enjoys life. And they're not with you. You're not with them. But there's a way to avoid that. Okay. I'm talking about the things. Thank you. Let her go.
Thank you, sir.
Yes, ma'am.
Okay, yes, sir.
In this case, there is a motion to revoke probation that's been filed. It was filed on September 19th, 2025. And in summary, as you probably know, but for the record, this states that on June 19th of this year, God bless you, you were placed on 6 years deferred or unadjudicated probation for the offense of assault on a family member. And looking at that indictment, said intentionally, knowingly, or recklessly causing bodily injury to a member of your family, household, or person with whom you had a dating relationship by pushing that person down with your hands, and you didn't intentionally, knowingly, and recklessly impede the normal breathing or circulation of the blood of the victim by applying pressure on the person's throat or neck and blocking their nose or mouth with your hands against the peace and dignity of the state, signed by the grand jury foreperson. So that constituted a third-degree felony. So you were placed on probation June 19th, 2025. Is all of that true and correct?
Yeah, you said.
Okay. And raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, lower your hand. And once again, you were placed on probation in this court for 6 years deferred or unadjudicated probation for assault on a family or household member by impeding breath and circulation, a third-degree felony, and you were placed on probation June 19th of this year. Is all of that true?
Yes, sir.
Now, we have didn't take long. There's a motion to revoke unadjudicated probation that was filed September 19th, which would have been exactly July, August, 3 months after you were placed on probation. Number one, it states that you committed the offense of assault, family or household member by impeding the breath or circulation on or about August 4th, 2025 in Hardin County, Texas, in violation of condition 1 of your deferred or unadjudicated probation order. Do you understand what you are charged with here, sir?
Yes, I do.
Do you? He says yes for you, but is that true? Yes?
Yes, sir. Yes, sir.
Okay. Then number two, Alex, and this says this is in violation of condition 1 of your probation order, which is do not commit another offense against the laws of the state or any other state or the United States. The second allegation states you committed the offense of interfering with emergency requests for assistance on or about August 4th, 2025 in Hardin County, Texas. And that must have been something arising from this other incident in violation of condition 1 of your deferred or unadjudicated probation order. Where is that found, that crime?
The impeding or are you talking about that one?
Interfering with the request for assistance.
It's in the.
Is it in the penal code or in
That's
nothing?
in the penal code. I remember.
Interference 42. Yeah, 42.062.
Yes, sir. Somewhere near the harassments and the stalkings.
Okay. 42.062, interference with emergency requests for assistance is exactly what was alleged here. An individual commits an offense if the individual knowingly prevents or interferes with another individual's ability to place an emergency call or to request assistance, including the request for assistance using an electronic communication device in an emergency from a law enforcement agency, medical facility, or other agency or entity, the primary purpose of which is to provide for the safety of individuals. An offense is a Class A misdemeanor, except that the offense is a state jail felony if the actor has previously been convicted under this section, which I don't think that's what he was convicted of. Okay. So do you understand what you're charged with in allegation number 2?
Yes, sir.
Yeah, speak out. Okay. What are we doing today?
Bond hearing. Yes,
Is that
sir.
right?
Yes, sir.
What's his bond line now? No bond?
No bond because he was transferred from Hardin County to here. You wanted to have.
All right. It's your motion. Go ahead.
Okay. Your Honor, I guess we'll just start with, basically he's on deferred, so his.
Okay, I know. You have
Here's what
data or testimony to present?
No, sir, except that the allegations in the motion to revoke probation for the probation that he's on, he is entitled to a bond. Here's what has happened, if I may proffer. In Hardin County, he's been in custody since September. He made bond in Hardin County and they put terms and conditions of release on him. So he already has a monitor. In fact, he's wearing that on his leg.
Mm-hmm.
He already has terms and conditions of distance. He already has terms and conditions of contact. He has many terms and conditions. There may be a term and condition that the state requests. But at this particular juncture, we're respectfully asking for a reasonable bond, a bond at around $25,000. And I think the state has a request for a condition that they'd like the court to consider.
Don't tell me the victim in this case is the same victim in the underlying indictment. Is it?
No, the
A
underlying,
different victim?
it is a different victim.
It's,
This is the
the
indictment.
victim advised that her fiance, the defendant, okay, this was the fiance.
Yes, this was a that type of relationship which ensued after he got on probation or while
and
he was on probation.
So the original,
right after.
on the original case, he was placed on probation, or he was accused of assaulting the mother of his children. Is that right?
No.
No.
No, sir.
It says
Just a girlfriend, but
it says as over the way their respective children treated each other.
No, sir.
Wait, reason. What was the relationship with this first person?
girlfriend.
A different girlfriend,
Yes, sir.
but a girlfriend. Okay, go ahead. What else?
I guess that's what we're asking as far as bonding, that you uphold the terms and conditions that are already on him from Hardin County, which he has to monitor and everything else.
Is there a probation officer on him?
No, Your Honor.
Does somebody have a pre-sentence report?
I do, Judge. I'll have to print it off, but if you're looking for his priors or what was alleged in the pre-sentence report before,
Yeah, I want to see what.
I show in February 27th, 2022, he had committed an offense of assault causing bodily injury to a family member, was given 1 year deferred probation on November 15th, 2022. And then on November 21st, 2023, he committed this offense that he's on probation for. So it was just shortly after he got off probation on the misdemeanor.
So this is going to. So this new allegation would be a third different assault on a family member.
That's correct, Judge.
Within how many years? Within
Well,
what?
2022 was the first one, February 27th, 2022.
Two. And then
The second one occurred November 21st, 2023. And then this one was on probation for this. I think he was placed on probation June of 25 and committed this offense September 25. So if there is a bond, which I think under the deferred he generally is entitled to, but he's committed a felony while on probation for another felony, they would ask for an extremely high bond, at least $250,000 plus home confinement if he gets it, and no exceptions of leaving his home, not for work, not for anything other than seeing his lawyer.
Now, Your Honor, his family is here.
what did they have to do with any of the alleged assaults? That's what I'm worried about. The families, they're always going to be here.
You know, the family,
Let me speak. The family, this is what's annoying about it. They're here. Okay. This is the third assault in just a short period of time by a close member, a relationship, who has a relationship with these people. That's what I want to know is what's the family doing to keep that from happening? If they're not involved in the deterrence of it, I don't need to hear them.
They-
I really don't.
Well,
Let
they-
me speak and finish.
I'm sorry, I thought you were. I apologize.
How can you do? I'm still speaking.
I'm sorry, Claire.
We can't, but we can't both speak. Or we can only take one at a time. But family assaults are the most dangerous and the volatile of them all, and that's why we're very sensitive about this. And this is, I mean, three uniquely similar situations, and he's putting, when somebody puts their hands around someone's throat and squeezes, there's only one intent, and that's to kill.
Well, that is.
No, don't interrupt me. I'm still speaking. You're going to have a chance to respond. That's exactly what it's all about. You got to breathe, and when you prevent somebody from breathing, they're going to die. And that's in the underlying indictment. It's alleged in the indictment that he pleaded guilty to. Then we got, let's see, a prior conviction, you said, Mr. Laird?
It's prior deferred probation.
For what offense? And that was in 22?
Yes, sir. He was given, the offense occurred February 27, 2022, as assault causing bodily injury family member. On November 15, 2022, he was given 1 year deferred probation. And then he committed.
What was the underlying facts of that? Does it show?
The first one,
What the assault, how the assault occurred?
let me see if I can find that.
But while he's doing that, here's on this one, on August 5th, committed the offense of assault by impeding breath or circulation again. He strangles people. No. What do you do when you stick your hand around somebody's neck and squeezes? That's strangling.
That is your arm.
All right.
Yeah.
He's done it twice, according to this. And then I want to know what happened in the first case of his first love interest. Man, that's just incredible.
We get to the probable cause, Judge.
Just on a side note, you're getting it all wrong. You're supposed to respect and care for the people you care for and love,
Yes.
not strangle them.
Yes.
Okay. I didn't know if maybe you didn't understand that, but you understand that clearly.
Probable cause says on Sunday, February 27th, 2022, at 3:16 hours. Officer dispatched to 1205 MacArthur Drive, reference to disturbance, possible assault in progress, called in by a juvenile. Upon arrival, officers on scene overheard a loud thud, and upon entry found that the accused, Colton Barrera, was assaulting his living girlfriend of 1 month by throwing her inside the bedroom up against a wall multiple times, causing her pain and bodily injury. Barrera was observed to be intoxicated as the assault occurred after he had arrived home angry. Barrera was placed under arrest for Class A family violence.
All right, go ahead.
Thank you. What I'm going to say is that the families here, when they hired me, the very first thing I tried to do was get him civilly committed with a committal because he's been diagnosed as bipolar. Now there's extenuating circumstances and facts that are part of this new case. That's when his family came to me, and that's when I began to do it. I couldn't get it through the county judge to try to get that. Otherwise, that's where I was trying to get him back on his meds, back where he needed to be. And that was the whole process of them hiring me.
What medication are you talking about?
His medication for his bipolar disorder. He has major depressive disorder. Of course, he has ADHD, but he
How long has he been on medication?
Since how many years?
I've taken that for probably 5 or 6 years consecutive.
Oh, wait. Okay. So whose fault is it he's not taking the medication that was obviously prescribed for his situation? Whose fault is that? Who's keeping him from swallowing the pills?
Right. And
Who's doing that?
well, his family has come in and tried to start do that. They tried to take him.
No, it's his choice, huh?
Well, yes, sir. But I'm just saying, as far as the family, where's the family going and where is his support team? He has a support team. I tried to get him into Oceans. Oceans was considering taking him, which is a long-term treatment facility for mental illness and other disorders. I couldn't get the committal into MHMR or B&H in order to get from there to Oceans. And so that's where we are. When I asked the court for a bond, the court said no. Bring.
I'm asking, here's what I'm more concerned about. Is he competent mentally? Do we need a competency evaluation?
He's been able to speak with me.
Yes or no?
No.
There's not a question about that?
No, sir.
So the choice is his. How do you prevent that? They can come in and help him all day long, but he's got to swallow. He's a grown-up. When we're diagnosed with something, unless we're incompetent or unable to take care of ourselves, he's out there alone. He's or independent, and as long as he's independent, he's got responsibilities. When you're diagnosed and you have medication, you're supposed to take medication. If you refuse or fail to do that, that's your fault.
Yes,
And other people are getting their necks squeezed here. Well, I'm sorry, the family can't do it. He's the grown up too. Either he's competent. If he's incompetent and the family has to help do that, then okay. But he's ambling about as an independent human, and that has responsibilities to it. You've got to not harm anyone, follow the rules,
yes, sir.
and give each person respect. Those are the three requirements. Don't earn any money, live peacefully, and give each person respect. Well, this is the third event of a similar fashion that's being alleged here on this court's watch. And I've got problems letting him go out independently when he has had two situations here and is not acting independently with wise choices and responsibly. And we're not just talking about he curses at someone. He's squeezing people's necks. He's had a habit. He's got a history of that, which can cause death.
Yes, sir.
All right. There's a lot that needs to be done here, which is consistent pattern in just a few years that should have been addressed before this. But nonetheless, it's on my watch, and then I'm going to address it.
Yes, sir.
But we're going to do it responsibly and in a aggressive manner that moves forward, because I'm not going to put another person who gets assaulted while he's on a motion to on probation on my watch. They'd say, who's to blame on the front page, and it'd be my picture.
Yes, sir. I understand. Now, some of his competency is based on what we did in the Hardin County Jail to get the doctor to see him and get him medicated and get his medicine to be here. So where he's at right now is medicated. The terms and conditions that the court has to put on him from home confinement, the monitor is already on him. He has the leg for that with all the other conditions.
He was told by his doctor to take medicine, right? He was told by his doctor to take medicine, right?
Okay.
And he's not doing it.
Well, he's been doing it in the jail.
No, did he? He's doing it in the jail now. But I mean, when he's in the free world, he made a conscious choice not to.
No, but he is medicated, has medication. So, I mean.
But doesn't it have to be imbibed, taken in, and swallowed?
It does.
That's his, and he's not doing that.
That's
what brings him up here.
Well, he's doing that at this point, Your Honor. If he
Because you know why? Because he's in jail and they're forcing him down. It seems like that's where he needs to be to ensure that he will stay medicated.
That's not a forcible thing. He is voluntarily taking his meds. They've never had to do anything like that.
So he intentionally didn't.
He wasn't taking his medication, Your Honor. But as far as the ability to have bond, he's entitled to bond with terms and conditions that this court can put on him. And home confinement, taking his medication with his family. He's not living by himself. He'll be living with his mother and father until we get this resolved.
Anything else?
No, sir.
All right. I'm going to agree. He's entitled to a bond. $250,000 is the bond. If he posts a bond, he will be home confinement. He cannot leave except with someone from the family escorting him. He has to be with a family member at all times. And they can bring him to and from your office, to and from court, to and from the doctor. He has to have a GPS device, so I know where he is at all times. And he has to take the medicine that he is prescribed that he doesn't seem to take. What other conditions are the state asking for?
Well, of course, their standard bond conditions are no contact with the complainant, either directly or indirectly.
And can't have any contact with the victim, and that's in all cases. Now, are y'all ready for a hearing in January?
I think we would need to get discovery, but what about
What discovery do you need?
discovery on the case?
It's going to be discovered on the new case that they have in Hardin County.
How long is it been? How long?
First, I heard you say you had an opening at the 1st of February.
For them.
For, do we have MTOP hearings first part of February?
That was just one that's all I'm saying.
I did set one, guy.
Yeah, we set them when we were able to squeeze them in, and when we do some dates on MTRP hearings,
Yes.
most MTRPs are not contested, but the ones that are contested, so you don't know how long it's going to take. So we'll set it though in first part of February, and she'll let you know, okay,
Yes, sir.
when she can iron it out after the first of the year.
Okay, that sounds good.
All right. What else?
I think that's a.
Is there, what's the status of this Hardin County case? What are they doing on it?
They're indicting, they're moving forward.
They're going
So,
to indict?
yes, sir.
Well, do you know when?
They've indicted.
Oh, it's already been done. You don't have, do you have a copy of that indictment? When did they do that?
I don't know.
They did that,
Okay, so the grand jury deemed probable cause that he committed a crime.
yes, on, September, I don't know. Was it? I see that.
Was this it?
Yes.
This is the way they do it?
The discovery volume.
Do you have a copy of this? This indictment?
No, Your Honor, do not.
Can we make copies for everybody?
Yes, sir.
Because I want one, and the state ought to have one.
Yes, sir.
And then, thank you. Is he getting all his medicine? He's been diagnosed to.
Yes, we have aggressively pursued that avenue. I mean, that has been progressively pursued since day one. Just
You gotta,
dealing
we're
with.
gonna have to figure, I have to tell you what to do, but you're gonna have to figure what's failing here. The doctor's doing their part. He's got to be doing his part. How are you going to ensure that that's going to be done as your test?
Yes, sir. And that was part of
Because, man, next time, shame on somebody else other than him.
Yes.
Somebody is, what in the world? How many times does this have to happen?
But there's a support team dealing with his medication.
It has to be effective. It has to do the job,
Yes, sir.
whatever it is. But failure is not an option here because he's looking at going to prison
I know. Yes, sir.
unless the fact finder can be convinced.
Right.
Because all that comes up at a trial or a hearing of past misconduct, and it's too similar.
Yes, sir.
Everybody asks, what's the problem? We all take medicine to some degree, but we take it
I'm hoping to have.
like it's diagnosed, or else it's our fault.
Yes, sir.